Hello, welcome to our weekly COVID updates for employers and foreign workers. I'm just going to give it a few minutes so that folks can get situated and get online. And I hope you all had I know this has been some trying times, and the country is truly, experiencing some very difficult situation. So I know that's got to be tough for everyone, and it takes a toll. It makes us all feel a little hopeless. And in the midst of everything else, we hear about all these changes that are going to be happening within the immigration arena, which is what we want to kind of tackle today. Our goal is always to make sure that we are disseminating information to make your life easier. So if you are, comment on our videos, email us at info@challalaw.com if there's something specific you'd like us to address. But share it with your friends, because the more we're able to get this information out, the easier people's stress levels will be, because they're getting the right information and it's not fake news or something you read off the internet that may not be substantiated. So let's get started. So first, our agenda. We're going to recap some of the topics we spoke about last week. But the focus of this week's webinar is going to really talk about, I know that everyone's heard the rumors about proposed additional restrictions on temporary visas. So what exactly can the president do? What's the authority? And if there's anything else that is in the pipeline, what's the timing of it? How is it that they can roll those things out? And then finally, what are the other updates? So first, recapping last week, we talked about the various legislation, some of which had no impact at all. And we talked about the presidential proclamation. If you remember, only precluded people who are seeking employment-based permanent residence from overseas from entering the United States. It had a lot of exemptions, so it was really much ado about nothing. But I had warned that within the provision there was going to be, they had stated that they may impose additional restrictions within 30 days. 30 days was Friday. So we didn't hear of any additional restrictions there. And then the constant pull for having, the process made easier for healthcare workers that are working on the line. And we're going to try to interview one of those healthcare workers in a couple of weeks. Most of you may not know this, but a vast majority of the individuals that are providing service care in our rural areas in the United States are doing it pursuant to an H-1B. And there's been a lot of concern for those individuals that, they're on the front line fighting COVID. If they happen to get sick or if they die, there is no process for their families. They would immediately have to leave the United States. So, this is something that is of great concern. So I hope Congress gets its act together and is able to actually effectuate some change. So if you didn't get a chance to check out the presentation from last week, go to YouTube at challalaw.com and subscribe to our YouTube channel, where we'll be putting up a lot of information on the various immigration issues. I want to give a shout out right now to my marketing director and our client services director, Kara Wood, who gave birth to a new baby girl last week, 2 weeks early, and baby and daughter are both safe. We wish them the very best. That was, life goes on, and it's wonderful in the midst of all this chaos to hear wonderful news like that. Now, if any of you know me very well, you'll know that I'm not technologically very savvy. That's not one of my strong points. That's her strong point. So we will still be having the weekly COVID webinars, but I'm actually putting all the PowerPoints and stuff together and beginning to really understand, you know, the work that she has to put in every week to get me here. So we want to thank Kara for all her work. We want to be excited because there's a beautiful new life. And maybe that's a good reminder for us to sometimes take a second in the day to not be so consumed with all the negative that we're hearing and try to find some of the positive to help us keep going, because that's what feeds your soul, right? So let's go on to speaking of the negative. You have probably, the news was filled with how there's going to be additional restrictions on H's and L's, and the president's going to sign an executive order. And so what exactly can the president do? So the president has tremendous authority under INA 212F, which allows the president to prohibit entry into the US of any foreign national he deems would be detrimental to the interests of the United States. Now, there are two prongs to that, okay, that I want you to focus on. It's entry into the US, and second, that he deems would be detrimental to the US interests. So let's say, for example, for kicks, the president doesn't like people from a certain country. They can't arbitrarily just say, we're going to stop them, unless they can demonstrate that they're going to be detrimental to the US interests. And so it's going to be really interesting to see what they will be able to do under that exactly. So whenever a president finds that the lawful entry of any foreign national would, you know, be detrimental to the interests of the United States, he may by proclamation for such a period as he shall deem necessary. So there's got to be it has to be temporary in nature. Suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem appropriate. So there's a lot of portions to that. There is the period that shall be deemed necessary, the suspension of the entry, could be immigrants or non-immigrants, or the imposition of entry, you know, requiring any restrictions that he or she may deem appropriate. So what that means is that, you know, it's entry. And so for those individuals that are already in the United States, really the president does not have authority through executive order to really institute that, although we've seen it done before, where certain benefits were given. And there's a difference between giving a benefit, like when they had issued the relief for DACA, but there's also, you know, some other requirements that were put in place after that. So what were those requirements? So the president can bar entry, as we've seen him do through numerous travel bans. So what is it that he can do? Well, the speculation is he can suspend the entry, not of the people that are already here, but the entry of H and L visa holders, or achieve a similar result by, remember, he can impose new conditions on their entry, such as preventing the entry of visa holders who are not paid at the highest wage level. And that's going to cause a lot of problems. So, you know, it may be given in certain limitations. So remember, it's got to be for a temporary period. And the restrictions have to be deemed to, they have to demonstrate that they will be that banning these people from entering during this very particular period is in the best interest of the United States. Now that's, you know, because any proclamation that's made is probably going to be challenged, but, you know, that's really it's not such a high burden, but typically they have allowed it for when we think it's a security threat, which is what the basis of the travel bans imposed. But they had to construct it very narrowly because otherwise it was the first few renditions of it were thrown out. And preventing the entry of H-1B visa holders who are not paid at the highest level would be a tremendous burden on employers. There have been recent studies that have shown that, the folks that are out of work are not necessarily those individuals that are, taking the jobs that the H-1B visa holders are currently holding. Here is someone who had a question. My H-1B has exhausted for 6 years. My perm is in audit. My perm was filed October 2019. Due to current circumstances, I've used all the 6 years of the H-1B. I have to wait till October to make an extension of my 1 year based on the pending perm. Currently, I've changed my status to B1 right now. Since I've used all the 6 years on an H-1B, will it be possible to extend the visa in October? Well, we've talked about this before. There are two ways in which you can extend your H-1B. One is, of course, if you've got an approved I-140, and we're going to talk about the resuming of premium processing for I-140s in a minute. But if an I-140 is approved and you can't adjust status because there's a backlog of visa availability for permanent residents, then you can obtain a 3-year, extension. If the other way you can get an extension is if your I-140 and or perm has been pending for at least 1 year. And so since your perm is in audit, depending on what the type of audit is, if it's just the standard audit where they're going to review documents, and that should be fairly quick. But if it's going to be something more complex, then it would all depend on that. And know this, that let's say for any reason post-audit it gets denied. While it's on the appeal, while you're appealing it, you can also apply for the 1 year extension. What I'd like you to do is really think about, instead of changing your status to B1, whether you should have changed your status to F1, whether that would have been a better long-term solution for you, because the USCIS has said that they would give great discretion for the issuance of the B1 visa because of travel restrictions. But, given the processing times, you won't hear about it anytime soon. You can only ask for a B1 period of stay for 6 months. So if you've asked for something beyond that, so those are the types of details and types of issues I would look into. We have another question. My priority date just became current under EB2 after 11 years wait. Oh my God. I-485 has also been filed. How long will it take for a decision given the present circumstances? What are the odds of an unfavorable decision? Thank you for taking my question. Please be safe and stay healthy. Oh, that's very nice of you. So congratulations. I know that is really very, it's a long wait. And I know that you're probably still very anxious because, it's not over till it's over, but it's the processing times are ridiculously long. So I would expect maybe, hopefully, fingers crossed, close to end of 2020, but you should get your work authorization within 5 to 6 months. The odds of an unfavorable decision. Well, usually it's, unless at the I-140 stage, at the 485 stage, they're really looking at you as an individual. So have you committed any crimes? Do you have any bars to the, based on health. And then finally, the one that's most common in employment-based cases is that, are you still working for the same employer? So that would really dictate if there's going to be an issue. Because if you're working for the same employer, you have to file an additional form, and there's a whole other process that's associated with that. But if you email us at info@challalaw.com, I'll respond to your questions specifically based on the facts of your case. I'd be happy to do that. And then I'm furloughed since 45 days on an H-1B. You're welcome. How to check if my employer has revoked my visa or not? Well, if you're furloughed for 45 days, that means you're still within the 60-day. I'm going to assume your H-1B is still valid because you want to know if he's revoked your visa or not. But you're within a 60-day period of stay, like the grace period, the one-time grace period per H-1B term. So if you find another employer and you are able to get that employer to transfer your visa based on the 60-day grace period, it wouldn't matter whether they revoked it or not. So you would still be good. So you as well, Lilith, if you want to email me at info@challalaw.com, we can talk about that in greater detail. And so I think somebody has raised their hand in chat. My I-20 on an F1 is ended. I'm not able to travel back. Converting to a B1 is a solution. Yeah, I mean, it could be a solution. You know, the other thing you may want to do is, try to get another F1. And I say that because B1s, it takes such a long time for the B1s to get processed. And there's a higher likelihood of a denial on a B1 than there is on an F1. So if you can get an F1, I would suggest filing for an F1 instead. So let us go on to our next. So we've talked about what the president can and cannot do, but what can the USCIS do? Now, these issues that we're going to talk about now, make no mistake, they're not COVID-based issues. A lot of this has been brewing for quite some time now. They're just using this as an opportunity to impose the additional restrictions. I know we reported, I think late 2019, that there were in the works issues to revise the definition of a specialty occupation, and also revise, when and where, or how rather, they would have the definition of the employee-employer relationship. But, and if you don't follow us on social media, I would suggest that you do. If you haven't signed up for our newsletter, we wrote about this in 2019. It's important to know proactively what's in the pipeline. So what we did was we looked at some of the agenda items they had, and these were the two agenda items. So it hasn't even come to, they haven't even published proposed regulations on, proposed changes on that, but it's just good to know ahead of time what's coming up so you can plan accordingly. So one of the things that has been hot and heavy for the longest time, now this was currently at the OMB last year, is rescinding the regulation that allows many spouses of H-1B holders to work, the H-4 EAD. So they have gone through the process for that already. So that may be something that is real, and they will roll out very shortly. So what is it that they have to do before they can the USCIS just immediately issue a rule and impose that? Not all the time. There are limited situations. So let's think about what they have to follow. What's called, every government agency has to follow something called the Administrative Procedures Act. So what does that act outline? That act outlines that a notice of proposed rulemaking be published in the Federal Register. So the agency will publish in the Federal Register, this is the changes that we're planning to make. The notice must include the date the rule will come into effect, the legal authority the agent has to propose the rule, and the substance of the rule, right? And so, and typically the agency will, in their notice, they'll say, please send your comments within a 30 to 60-day period. More often than not, we've seen it at a 60-day period. The agency is required to then review all the comments and then submit their proposed and incorporate any changes based on the comments and submit the final rule to Office of Management and Budget, OMB, and then publish the final rule, including the effective date. And that's what they are required to do. As you can see, there is some time. So they started the H-4 proposed changes. I think it was discussed December of 2018, but it didn't even go to the OMB until September of last year. We've got 2 people who've raised hands. Okay. Hi, my current H-1B 6 years maxing out is getting over by May 2021. My current employer is not ready to initiate my GC. But I have a potential future employer ready to do the GC with future employment basis. Do you think this is doable with the current COVID situation? Absolutely, you can. Here's one thing to think about. If you are trying to file a permanent residence process with a future employer, someone you're currently not working for, you can do it because permanent residency is prospective employment. It's not current employment. But the one issue is going to be when you file your I-140, the employer has to demonstrate that he has the ability to pay your salary. So how does he do that? The vast majority of the time, if they have been paying you whatever the perm salary level is, then they can say, because we've been paying you, even if my tax returns are negative, even if I have no other way of demonstrating ability to pay, the mere fact that I've been paying you demonstrates ability to pay. If you're not currently being employed by that employer that's filing your permanent residence, what you want to do is to make sure, hey, are you going to be able to demonstrate that you have the ability to pay my salary? And that's really important, because unless they're able to do that, so when you say with current COVID situation, unless they're able to do that, your I-140 will be denied and it won't help you. And especially because you've got a March 2021 deadline, it's got to be started now. If you want a memo or if you want some additional information, Srinivas, on the requirements of the ability to pay on an I-140, email us at info@challa.com and I can send you a memo so you have what the requirements are. And maybe you can use that to talk to your employer, because I wouldn't want you to go through the process and have a problem at the I-140 stage. Another question, should I wait for 60 days from my last work day and check with the USCIS, or file a B-2 if I'm not able to find another employer to sponsor my H-1B? The employer has not confirmed my visa termination. I cannot ask this question to the employer directly. So I wouldn't wait for 60 days. I would file it prior to, if you want to file a change of status to a B-2. Like I said, if you can, try to file the change of status to an F-1. There's tons of one-year programs. I think that your likelihood of getting that approved would be much higher, and you've got a longer period in which you can, try to find someone to sponsor you again, and you're getting additional educational skills. So that's what if I were in your situation, that's what I would do. One more question. I have completed my full H-1B tenure and am back in India. My GC process has started while in India, and then my I-140 is approved. Can my previous H-1 be extended based on the current I-140 approval? Yes, you can. So once your I-140 is approved, your employer can file a new H-1B, and they can ask for the full 3 years. So, and I would do that sooner rather than later, just in case there is additional restrictions on entry of H-1Bs. So you want to make sure to get ahead of that. If your I-140 is approved, there's no reason why your employer shouldn't be able to file that immediately. So I would get that going as soon as you possibly can. Another question. Wow, this is a long question. Okay. I have gotten an RFE May 5th for my H-1B extension because of my educational background and specialty occupation. I'm working as a full-time employee in a US-based office. Last 3 years, I have been working for the same employer. My I-94 is expiring July 16th, 2020. And also my GC process started last year, and labor is certified. I'm gonna apply for the I-140 now. How much chance to get an approval, whether I should wait for the RFE response or should I switch to another employer in 45 days? What's the best way to handle this situation? Well, we've been, I don't know, who's responding to your H-1B. I know that we've been really successful with specialty occupation and educational issues. And we try to tackle that on the front end by issue spotting to make sure that we can avoid the RFE. But what I would say to you is go ahead, and if you'd like to email me your RFE, I'll take a look at it and I can tell you what the chances are and what you would need. You don't have to wait for that approval to go ahead and change employers. What I would do though is you can file I-140, and we're going to talk about the reinstitution of premium processing. And I'd wait for your I-140 to get approved. That way you can go ahead and ask for a full 3 years so that at least your I-140 is approved with this current employer before you change. Once you change employers, you will still have to go through the PERM process and the I-140 process again, but you can keep getting extensions based on your previous I-140. Number one. Number two, once your I-140 is approved, you are able to you are able to maintain your priority date. So at this stage, you don't want to lose that. So don't change employers until your I-140 is approved. Once it's approved, you can change employers, ask for the full 3 years. And email me your RFE if you'd like, and I can give you my thoughts on what the likelihood of approval is and what the type of evidence you would need to submit to ensure that it does get approved. And then we have another question. Can I file for an H-1B transfer with another employer for 20 hours of work? Yes, you can. You can do part-time employment. So part-time employment H-1B is absolutely permitted. They do have to pay you for whatever period is stated on the part-time employment, but you are permitted to file that. And a follow-up to the question before, my educational, I'm gonna, so you can email me at info@challalaw.com. Electrical engineering, they've tried to use electrical engineering to say that it's not a specialty occupation for IT professions. But there are numerous articles and there are a number of publications and other authority that shows that electrical engineering does prepare you for, most IT positions. And I don't know what category they classified you as, but email me the RFE and then we will see how we can, address that. I know I've got a few people asking me questions on the Q&A. Let's move forward just a little bit so we don't lose. So the critical thing is, by knowing all these changes are taking place, this is no time to be sedentary and not be deliberate in your immigration actions. You've got to act strategically. You've got to act, fairly quickly, and you shouldn't be. This is not wishy-washy time. You got to make decisions, and you got to make them smart. like I was telling the individual who had an I-140, who got an RFE on their extension, I said, wait, don't file it right now, wait till the I-140 is approved. So those are the types of things you've really got to think about. When the individual who was overseas said their I-140 was approved, I said, file for your H-1B for your 3 years now, because those changes, we don't know when they're going to come up, but it's better to be proactive than reactive once it's been implemented. There are also proposed changes to the L-1, and this is something we also reported in 2019 that was on the agenda. And to clarify the definition of an employment and the employer-employer relationship, and the employer's pay appropriate to L-1 visas. So next week we're going to actually talk about what are some status violations that are different with each visa, because the imposition of a wage is only there for an H-1B. It's the labor condition application and that requirement that makes the employer who doesn't pay the wage violate, or it becomes a violation of your status if that doesn't take place. So it's really important, and it's different for each one. So with the L-1 currently, they have no wage requirement. So they're looking to see if they can impose a wage requirement for Ls. And, again, they would have to do that through the Administrative Procedures Act or an act of Congress. That is not typically something that can be done through executive order. OPTs have been getting such a bad rap for the past, God knows how, since the administration has taken effect. They've talked about getting rid of the STEM OPT and proposed changes, and there's all sorts of absurd notions that some senators who are not familiar with the process have been making, such as the OPTs are taking jobs from US workers, which is not the case. And I'll tell you, I think that you're going to get a lot of resistance from academic institutions, because as it is, there has been a drop in international admissions in this country. The universities are already hurting. This will make things worse if we have a drop of international students. International students not only bring to the United States the best and brightest talent from around the world, but it also brings to the United States a lot of revenue for the localities, for the institutions. They are the reason why, certain universities haven't had to raise their tuition, because our U.S. tuition is being subsidized by international students. And if you make limitations to OPT, you will be doing that at the same time that other countries like Australia, Canada, other places, make it really easy for international students to obtain work authorization afterwards. There was a really good article last week on how Canada, not because of their restrictions, they have been very welcoming, but because of COVID, there has been a reduction in immigration, and that's really hurting their economy, in addition to everything else that has been happening. But they would again have to do this through notice and comment, and it's not summarily something that they can change immediately. They may institute a temporary restriction on the issuance of OPT, but we will be keeping track of that. And at the end of this, on this webinar, we've got links to sign up for our updates, so you get them, as and when they happen. I happened to learn how to, and it's been exciting to learn how to use MailChimp over the weekend, so I now know how to send those out, but you won't get it unless you're subscribed. So subscribe, to our updates, so you can keep, like I said, so you can be proactive, know what's going on, and know what you need to do. Let me answer a few questions that we have. We've got some in our Q&A. My new employers applied for another 3-year extension of my H-1B, but I haven't gotten a response as the offices are closed. But my H-1B expired as of this week. I am unable to leave the country due to COVID, which I do. if your employer has applied for an H-1B, what that does is when they apply for an extension, you are afforded 240 days from the date of the expiration of your H-1B to work based on that extension, timely extension filing in the United States. You don't have to leave the country. You are invalid, even though your H-1B has expired, you're in what we call a status authorized by the Attorney General. So you are able to continue working for your employer and stay in the United States. You don't need to leave. So I hope that makes you happy. That's good news. And one more question, if the employer is not paid one-way return ticket, can this be considered as H-1B determination or abstain from work? Well, they have to, if, you know, did they terminate you? Did they officially say that we no longer need your services? Because the employer is required, and we had covered that, and you know, please go back, and I think it would be our second, either our first or second YouTube video on this, and that may help you know what they are required to do. But there are some compliance issues associated, employer compliance issues with the H-1B. So they, if they're ever audited, what the auditor will do is they'll look at the date that you've been paid, and suddenly, you know, this particular individual is not being paid. So they'll ask the employer, where's evidence that you terminated them? The employer will have to show that not only that there was a termination, but you had notice of it and you acknowledged it. And then they have to demonstrate that they offered you. They don't have to give you, but they offered you. They don't have to buy a one-way ticket, return ticket home for you. So what they will do is, you know, a lot of times the employer will say, okay, we'll offer you, do you want a one-way ticket home? We'll buy it. So they're not going to give you money for it. They'll buy it on your behalf, but they have to do those two things. And then they revoke your H-1B and labor condition application. Because until they do that, there's ongoing wage obligations. So one more question. I'm currently on an H-1B and is hoping to start my application for a green card. Is it a good time now to change status and apply for a green card application? Also, what is the wait time for an application from South Africa? Should I apply for extension on my H-1B first or simultaneously apply for the perm? It expires as of October 2021. Well, first of all, you can only file for an extension 6 months in advance of your expiration. So you can't file that yet. And this is a very good time to file your perm. But, you know, there are, you know, just as with, you know, H-1Bs and other things, there's certain things that, you know, the perm application, a lot of people will just file the perm. But the perm application has to be, that is the foundation for your I-140, for your 485. So I tell everyone that you've got to be really careful in filing that to make sure any of the issues that come up there, because that's the document they will look to. That's going to be the foundational document that is critical for your permanent residence journey. So you want to make sure that, you know, that's filed correctly, but this is a perfect time. Now, depending on what your, you know, background is, what geographic location you are, some of the things you want to think about is, you know, because they do have to place an ad for the perm, what type of response do you think would come up for that ad? And I can tell you that we've been processing a lot of perms, and we have not found that the unemployment issues have really impacted any of our perm applications. And that's because a lot of the people who are unemployed are usually in hospitality and restaurant. They're not IT professionals. So very few people are able to, you know, that are unemployed. It may be a little bit more than what it was pre-COVID, but not substantial based on the unemployment numbers overall. My dependent is going to college from this fall. She holds an H-4. Currently, if I change her to an F-1, will she become considered as a local student or an international student? Well, H-4s can stay under, they're considered dependents for a certain statutory period of time till the age of 21. After that, she can no longer be your dependent. F-1s are always going to be international students. But the other thing so you're going to have to pay out-of-state wages. But the corollary to that is she may be eligible for, after 1 year CPT, which she wouldn't be eligible for on an H-4. So there are other considerations that you may want to keep in mind as you're trying to assess when and whether to keep her. So it's age. That's the buck stops there. You have to file prior to the age. And most locations, I was special counsel to the Attorney General, including Ken Cuccinelli, who's the USCIS director, for a decade. I was planning to merge with another law firm, so I had to recuse myself from representation because there would have been a conflict of interest. But during that time, I drafted the domicile guidelines for the state of Virginia. And we looked at other states, and the vast majority of them allow H-4s because of the dual intent issue. Because most places for domicile, you have to intend to reside here indefinitely. So a person who is on an F-1, because you have to intend to return to your home country, it's implicit in the regulations, you can intend to reside here indefinitely. But in H-4, it's got dual intent. H's have dual intent. So you can intend to reside here temporarily and intend to reside here permanently. So therefore, they're eligible for in-state tuition. So I would think of all those considerations before you decide how you want to proceed. We've got someone else raising their hand with a question, but let me go forward just a bit to try to get this going. Okay. So we had talked about in the previous slide, that's why when I stop in the midst of presentation, you kind of lose your train of thought. We're talking about the temporary restriction on the issuance of OPT and how they could do that. Most likely, if they have to do anything for the people who are here, they have to do it through the Administrative Procedures Act. But I wanted to remind you that the presidential proclamation, the presidential executive order, can restrict all entry. So although he may not be able to do anything for OPTs that are currently in the United States, he can possibly restrict entry for OPTs that are no longer here. So does everything have to go through notice and comment? Not always. The agency may issue a rule without prior notice and opportunity to comment when the agency has good cause and find those procedures are impractical, unnecessary, and contrary to the public interest. So anytime they try to make a rule restricting, especially restricting the benefits afforded those who in good faith had relied on them, and they try to do that without doing notice and comment, there's going to be a challenge. And so you will know that it's got to go to court, and in court they've got to demonstrate that it was so drastic, that the public interest was so great that it was impractical for them to go through the notice and comment period. And I think for something like rescinding any type of work authorized benefits would probably not fall under that rule. So temporary rules, final rules, have an expiration date, while interim final rules just change the rules without public comment. And like I said, that's going to, it has a higher threshold, a higher burden that they've got to prove in order to be able to do that. And as I was saying, it ain't over till the fat lady sings. And there will be lawyers, not saying that lawyers are fat ladies, but the phrase is taken from the from the opera, that at the end, you know that the climax and the end of the opera is when because when she sings. So there will be a legal challenge. So any action will activate other actions that may delay implementation. So everyone is being highly vigilant on this. And that's actually why I got into practicing law, is because I like being the advocate. I like fighting for the, advocate means, it's basically that you are lending a voice to those who may not necessarily at this particular time be heard. And so we're all ready to, join in the fight and take on any legal action if they start trying to implement things without going through the correct channels. Let me take a question. Given the current proposed changes and restrictions, it is advisable to travel out of the country if I'm on L-1. No, I would not. If you could help it, I wouldn't travel outside the United States. Remember, I said that the president by executive order can restrict entry. And of course, he's got to base that on something that would be deemed in the public interest, but nothing that is within his purview. And the courts have taken the fact that the president has broad power in that. Please don't leave the United States. Here's another question. Does my H-1B grace period to find another employer or file a B-2 start from the last day worked or the last day paid up to, as the employer paid me 10 days on PTO? Yeah, so your 10 days, that's personal time off. So your personal time off is still, it's, leave you've taken personally. So it would be the 60 days from your PTO. So what you would do is when you file for a change to a different employer or file a change to B2, you would submit evidence that you were paid up till this period and that was the effective date of your 60-day grace period. I hope that helps. And someone made a comment, thank you for being such a strong supporter and advocate for our Southeastern community. Absolutely. I believe it's really important that all of us have to do whatever we can within our communities. And, I've been blessed to be surrounded by, as I think I mentioned a couple of weeks ago, my father during COVID had a stroke. And he's doing well now. But during that time, I had to rely on the great work of the doctors, Dr. Sahani, Dr. Coker, and his current caretaker, Dr. Banerjee, who has been, the doctors and their staff were just amazing. It was very hard because we couldn't go see him. He was very scared because it came on all of a sudden. And that's what each and every one of us have that responsibility to do, is to see in whatever way we can how we can help people. I remember when we were doing, here and there, we were doing all this pro bono work. I had an associate said, do you really think it's going to make a difference in the world? And I said, Mother Teresa said, if you can't feed a million, feed one. I believe if you keep feeding one, you'll end up feeding a million. So we all have to do the best we can to help each other out in this world. After all, we are spiritual beings living a human life. So, we have to be able to touch and help one another. There's a question. Let's see. My child turns 21 on August 1st, therefore will lose his status as an L2 on that date. As of now, he cannot travel back to India. Is there any extension possible? What about changing their status to an F1? Are they planning to start school or anything like that? I don't like the B2, as I've told you before, but B2 is also an option. But one of the things that they can do is file for an F1 if they want to go to school here and be able to do that. And it doesn't have to be, everyone thinks it has to be like a major university. It can even be a community college, right? Because you're worried about paying. Yes, he can file, okay, so the follow-up question is, he has an I-20, can he file without leaving for India? Yes, he can. He can file, it's an I-539, change of status. You have to file it, it's very quirky about F1, so you have to file it within, before 30 days of your date of current status expiration. So I would get on that now, but he is able to file, especially if they've got an I-20, they include the I-20 with the I-539 and you file for a change of status. It may not get adjudicated by the time he starts school, and he will probably most likely not be permitted to start school until it does get adjudicated because of the delays in timelines. But you know, that is something, you do not have to leave the United States in order to do that. So, you know, I wanted to highlight that a lot of you have asked questions that that are in our newsletters, that are in our Twitter feed, that are in our YouTube channels, and just think how good it would have felt to know some of those things instead of having to worry about them until today. So I'm asking you to sign up because you know, like I said, I'm committed to making sure that the community has the information. And very shortly, I'm going to be posting a video of my immigration journey, and you will understand why my commitment's so strong once you hear that. So be proactive. Strategy is key. Stay advised, informed, and prepare an immigration strategy. Don't do this in a vacuum. Make sure that you know you've got all the things in play. Other updates, some good news. The USCIS is preparing some domestic offices to resume non-emergency public services after June 4th. They're going to be contacting people who are scheduled for their interview. There's going to be delays because it's been a while since they haven't been open. And special procedures for naturalization hearings. So it's up and running. And premium processing resumes in phases. And I'll tell you this, they didn't resume it because of course, maybe it's goodwill, but the USCIS did not have any funds because of the downturn in processing and because they've closed off premium processing. It's $1,440 per petition, and USCIS, as opposed to other government agencies, is self-funded. So they've resumed this because they need the money. Otherwise, people were supposed to be laid off. So they're doing it in phases. So it's not going to happen for all, but we had a lot of I-140 questions today, right? So you I-140 people, effective June 1st, boom, today, USCIS will accept premium processing requests for eligible I-140 petitions. Not all I-140 petitions like national interest waiver, multinational manager, L-1, I mean EB1C, they're not eligible for premium processing. But if you've got a perm and you're filing an I-140, you're eligible for premium processing. So that's great news for all of you, because then you can get your 3-year extension, then you can get your priority date will be vested with you. And if you want to change employers, you can do that. You can continue to get 3 years extensions based on your previous I-140 approval. You will have to go through the process again. It's going to be 1.5 years. It's a 10 to 11 year wait. So you're not losing anything. And your priority date stays with you. So it's really a no risk, no loss endeavor. So you can do that. Next, effective June 8th, they'll start accepting premium processing requests for H-1B petitions filed before June 8th that are pending adjudication, and if they are CAP exempt. That means they're not subject to the cap. University petitions, other petitions, research institutes. All other I-129 non-H-1B petitions are eligible for premium processing if they were filed before June 8th and pending. So L-1s, E's, anything else, R1s, all those others are eligible for premium processing that filed before June 8th. So effective June 15th, premium processing requesting for those who are filing a petition either on or after June 8th and are exempt of the H-1B cap, because either, number one, it's a cap exempt organization, or it is a physician who is cap exempt, because so physicians usually come here and do their residency on a J1. J1 have a 2-year home residency requirement automatically for all medical residents. The only way they can remove the 2-year home residency is if they get a Conrad waiver where they have to work in an underserved area. Remember I was talking about how all our doctors that are in rural areas, a vast majority of them are international doctors on an H1. So that's, those are the people that are eligible for premium processing. So that's the Conrad waiver. Effective June 22nd, they expect to resume premium processing for all cap subject cases, including change of status for F1, and both for upgrades as well as concurrently filed I-129s. Now, one of the things is, if you had filed before they stopped accepting premium processing and they haven't refunded your check, you just have to give them proof of that and then file a new 907, alerting them to that fact. And they say that they can change this at any time. So it's good for right now. We have to wait and see. I think it just depends on, what their staffing levels are and how they're able to deal with this. Let me see, we've got a question. What is the average wait time for completing a green card process from Africa? Well, there are two things with permanent residence processing. There's the actual processing with the U.S. agencies, Department of Labor, USCIS. And that does not matter. It's country agnostic, those processes. It's the same for every individual. That, depending on your lawyer, could take anywhere from about 11 months. But so that's for everyone. Where the fact that you're from Africa may be helpful, and I don't know if you're filing EB, employment-based second preference, or employment-based third preference. So if you're applying for employment-based second preference, there may not be a wait time depending on when it's approved. So you would be able to file your I-140 and 45 at the same time, so you could get your employment authorization fairly quickly. So this is an anonymous attendee. If you would like to email me at info@challalaw.com with any specific questions, I'd be happy to let you know. Because not everyone is eligible for an employment-based second preference, and there's some things you've got to really think about on the front end to make sure that you can leverage that. So as I said, get the latest updates by signing for our newsletter. All the things that I talked about here, we pointed out about in late 2019. So you are responsible for your immigration status. So it's really important that you stay updated and aware. And I get this all the time. Oh, I heard from my friend did this. Well, each situation's a little different. And so you have to understand it in the context of how it applies to your specific case. And then you can make smart decisions as to what to do and how to leverage it so that, you're not caught in a rock and a hard place at the very end. We've got a COVID resource page, and we're still going to continue to have our webinar every Monday. Next Monday, I'm going to plan to talk about status violations in different types of statuses and what you can do about it. If you have any suggestions, look at my YouTube and I'd love to get your feedback and hear what you have to say and how you think we can make it better, because really I'm doing this for you. And so your feedback's really critical. So subscribe, forward it to your friends. We want to reach as many people as possible, because I think it's really important that, you know, everyone, like I said, you can't turn on the news, hear about the deaths, hear about, you know, the protests and what's happening to this country as a whole. And I'm very positive that we can get through this. We all came to the United States for a reason. It's one of the greatest countries in the world. It is, bar none. And you know, but in the midst of all of that, to have anxiety about your immigration status, I know how that feels. I have family members who know how that feels, but I've lived through that personally. And like I said, I think it's really important that I post that on our YouTube channel. So my goal is to make sure at least that part of your life is a little bit less anxious. So that's why I ask that you forward it to your friends and help me reach as many people as possible, because that's all we can do now. We can only help one another. The person followed up and said, I think it would be EB3. Well, email me, Mr. Anonymous Attendee, and let's see if there's some way that you could be filed under EB2, because EB2 is not just for master's degrees, but people with a bachelor's degrees and 5 years of progressive work experience. So, like I said, it's almost like a geometry question, you know, where you know what the answer is going to be, and then you have to find the theorem that goes with it. I am the anomaly for Indians. Math was not my strong suit. I have to say, I don't think I was very interested in it, but I did really well in geometry. And that's because it's like law. You know what the outcome is, and then you're trying to find, you know, the theorems that will fit that. So, Mr. Anonymous Attendee, if you would like, you can email me and we can talk it through and we can see how we can make sure that you file it in a way that's best for you. And then lastly, someone said, thank you so much for answering all our questions with so much patience. No, absolutely, that's what I'm here for. I'm here to help you. Like I said, I know how that feels. And I know I couldn't sleep, I couldn't eat when I was going through even though I grew up here, I was here since 1967. And like I said, I'll go through my entire story, which is, I swear to God, it's like a Bollywood movie. It doesn't even seem that something like that could be for real. But so I know I know what you're going through. So for me, this is not just about a way to earn a living. This has been a life mission for me, and I had to fight with my parents really hard to allow me to pursue this, and they still wouldn't. They wanted me to be a doctor. Surprise! They wanted me to be a doctor, and I got into med school, and I said, I want to be a lawyer. I want to help other people. And so thank you for taking your time out to listen to this series. I wish you all the very best, and you know, stay safe, stay positive. You know, I'm a strong believer that there are solutions for everything in life, and we will get through this. We will get through this as a country. I know it, and we will be stronger because of it. You know, they say, right, that you are, I am stronger in all my broken places. Sometimes there has to be disruption in order for you to really see what needs to be fixed. So have a great week. I look forward to seeing you guys next week. And like I said, in the interim, if you've enjoyed this, if you found this helpful, help me get the word out to as many people as we possibly can. And oh, thank you. Thank you. Thank you for the appreciation of the webinars. This is, like I said, something I really enjoy, connecting with everyone and helping them, I hope, in some way, navigate through this And someone had one last question. My dependent is going to college this fall. She holds an H-4 visa currently. If I change her visa, oh, I think we answered that already. I think you had asked it for both on the chat and on the Q&A. So, you know, for this week, like I said, stay safe. Thank you all for joining us. And I look forward to seeing you again next week. Until then, this is Lakshmi Challa saying goodbye. Take care.